Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh, and a very good morning to all of you. Let me take this opportunity to thank KLRCA for inviting me to this session. It is a great pleasure to be here, especially to have the opportunity to meet up a few old friends that I've not met for some time. I'm not even sure whether there is much relevance for you to listen to my session after having listened to what Andrew White and Malik Imtiaz have said. I guess majority of the audience in this conference would like to focus on what they have to say with regard to Islamic arbitration moving forward, because these are the most exciting part of the industry that is growing very fast and involving billions of dollars. Nevertheless, to be fair to non-banking practitioners, I think it is also worthwhile to take into consideration that there are other aspects where arbitration can play a role, and in fact should play a role. So that's my job, and I hope that within the short time frame that's given to me, I'll be able to spur some knowledge and information on what this entails. I will also, before I forget, highlight the fact that some of the questions that was raised by Malik just now regarding Section 56, 57, just to share with you my own experience. I had the opportunity to present a case before the Law Harmonization Committee of Bank Negara, which has the specific mandate of harmonizing between the Shariah practice and banking law in the country. And to be fair with you, to be fair to us practitioners, and to share my experience within that presentation, Bank Negara actually did not think about having a full hearing process when they decided to have Section 56, 57. They thought that if there is a Sharia question arise in the court will draft the question to them, send to the Secretariat for deliberation, and basically they will just reply to that question to the court. For them, it is almost just an administrative process. So during that presentation, I highlighted to them, no, it's not going to be that easy, because we are talking about various stakeholders, various parties with complicated disputes involving most likely, hundreds of millions of dollars. So you need to give the opportunity for hearing and, submission of cases. And that is when afterwards, the guideline that Malik mentioned in Bahasa Malaysia on how to submit questions to the Secretariat is later on prepared. But I'm sure they are, these are learning curve and learning experience for both the industry as well as Bank Negara, because these are new changes made after several years of gaining experience in regulating Islamic banking in Malaysia. So that process, that engagement, and that feedback needs to continue as well. And to be even more earnest for us in this session, later on you will also listen to Prof. Dr. Nku Rabiah, who sits in the Sharia Advisory Council of Bank Negara and knows the integral working process of the Sharia Council, especially when a question is referred to them either from the court or from the institutions themselves. So these are very good opportunity for you to understand that whole process. Coming back to my presentation, outside Malaysia, probably these are less of interest to the audience, especially because in Malaysia, many of us are fully aware of the legal framework applicable to Sharia. The Sharia aspect of legal framework that are applicable to the public generally and to individuals in particular. We have very long history of the application of Sharia in our country, especially in the area of family law. Of course, nowadays hudud become the other hot topic that carries on the impression and the debate over what is Sharia and how far it is applicable to Muslims in our country. But in other part of the world, there are important issues to address, especially when Sharia is not part and parcel of their legal framework. So how do you accommodate that, especially when the parties in dispute contractually have agreed to resolve their private disputes using Shariah principles or Shariah laws or Shariah arbitrators? And how does this later on become enforced in court, which are totally secular and may have no knowledge at all regarding Shariah? First of all, let me reiterate what may have been highlighted by other speakers as well, that arbitration is not alien under the Islamic Sharia or Islamic legal tradition. Even the Prophet himself has the experience of becoming an arbitrator before he was elevated to prophecy. And in another incident which is very famous in Islamic history, the dispute between the fourth caliph and the governor of Shams, they also attempted to resolve their dispute through arbitration. So this tradition and this practice has been entrenched and recognized within the Sharia for a very long time. In the case of modern application of Sharia, what is closest to us in terms of daily disputes is very likely that we would need to consider application of Sharia in family disputes, especially divorce and inheritance amongst Muslim persons, regardless whether they are residing in a Muslim country or largely secular country. And secondly, on commercial disputes, especially when the Muslim parties again explicitly inserted an arbitration clause in their contract that they want their dispute to be resolved according to Sharia principles, or to put their dispute before a Sharia arbitrator or a scholar to resolve it. Other than that, we need to also consider that, by the increase of globalization and international trade, there would always be a situation whereby the importance of national law that applies to the governing law of the contract would be an issue of conflict and therefore a requirement to arbitrate as well. For example, when the parties involved may be a company in Saudi, in Kuwait, in Qatar, or in Egypt, whereby constitutionally Sharia has always been recognized as part and parcel of the sources of law in that country. Okay. These are some probing questions that I believe will always arise whenever we talk about Sharia disputes beyond banking. The government definitely would need to consider these issues carefully, especially when they have substantial presence of Muslims within their society. We have seen this case being elevated to the government authorities in Canada, in the UK, in the US, because there is always this tension. The moment you mention Sharia, and because of all the negative media coverage on Islam and Sharia from time to time, there is always this tension within the society, the non-Muslim and the non-Muslim society, as to what kind of Sharia, as mentioned by Professor White just now, what kind of Sharia, which Sharia is going to be applied in this context. Yeah? So the government needs to understand this in the dynamics of their society and form some policies in order to ensure that this will be regulated in orderly manner. If they just leave it to the people, then of course there will be chaos, yeah? and of course uncertainty in the law as well. It is a very important question, because only the government can resolve this. Yeah? Only the government can mediate between subsets of the citizens in the society. So they need to be able to accommodate that. And of course, to be fair to the Muslims, there are other faith-based arbitration as well. For example, Beth Din or the Jewish court, whenever or wherever there are Jewish community in certain countries. These are very well recognized institutions. Of course, the Jewish, in terms of religion, has longer tradition than Islam, in terms of legal and regulatory framework for their community. So this has to be considered in that dynamics as well, i.e., to fairly treat every faith-based mediation or arbitration, should the private citizen choose them as their governing law or method of resolving dispute. Okay, let's try to go through this one by one. As far as evidence is concerned, there are clearly incidences or examples where arbitration awards have been recognized by the courts in the UK and in the US. I will share this, hopefully, inshallah, in my latest slides on some of these examples. So if it can be done in the UK, it can be done in the US, arguably it should not be a problem to be applicable to anywhere else. Because, of course, we have very high regard. Generally, the international community have very high regard to the integrity of the US and UK court. So the moment they recognize this type of arbitration process and arbitration award, you must give them the credit in terms of the evaluation and process that they have agreed to that. Okay. Second question is, how do they recognize and therefore ensure that these are reconciled properly within the constitutional framework of the country? If yes, why? If no, why? Yeah? Because, like I said, there is a need to manage the dynamics of the religious tension between various communities in the country. If we again try to look at the examples in the UK, I was there in the UK in 2004 when the Archbishop of Canterbury make a public lecture, deliver a public lecture that openly said that we should recognize Shariah and Shariah arbitration as part and parcel of the dispute resolution process in the country. It actually attracted a lot of negative remarks, especially from the media in the UK. I remember that the Sun newspaper actually held a campaign to bring down the Archbishop just for this statement, you know. But later on, just less than one year later, the highest chief judge in the country, Lord Phillips, also made a statement in the Parliament stating that this is actually the position under the law, and you should recognize it. If you can recognize then there's no reason you should not recognize Sharia arbitration, especially when it is done in the manner that is compliant with our law. Yeah? As I mentioned, in the case of Canada, they actually commissioned a committee called the Boyce Committee to prepare a report and make recommendation. There were more than 40 recommendations made by the Boyce report on whether to accept or not Sharia arbitration beyond what is already there in the Canadian legal framework, especially when it comes to family disputes and the protection of women's rights in any family disputes. Unfortunately, although the position taken by Boyd's report in Canada was that Sharia arbitration in the case of family dispute for Muslims, Muslim couples can be recognized, but the decision made by the policymaker is that no, we don't want to get into that complication. Your 40 recommendations is very difficult to adhere to, and therefore we just pass a law that says you cannot go to any faith-based resolution of family dispute. Everything is basically just falling back to what Canadian family law says. Yeah. But still, for me, it is a good learning experience for others who wants to tackle this issue. Then we also face of the issue of how do you reconcile. If you look at the decisions made in the UK courts, in the US courts, the judges went through a very detailed process in engaging with the Sharia arbitrators and trying to understand where they were coming from. And this is exactly why, based on the evidence produced before them, this is why they eventually decided that, okay, this is a reasonable arbitration award, and therefore we can enforce it and recognize it as legally binding. So it is not just because, you know, out of sudden this mullah or this qadi managed to convince the High Court judge or the Court of Appeal, and, you know, therefore the award was granted. So there was a proper due process, and this is where it is interesting to further study these cases and see how it can be developed further to facilitate dispute resolution among Muslims in many countries generally. Just now, in Malik's presentation, he highlighted about the constitutionality of Section 56, 57. Yeah? Whether you can actually use the force of law to tie the hands of the court and therefore abide by what is decided as Shariah by the Shariah Advisory Committee. But let us not forget that there is also this constitutional protection that parties are at liberty to decide on how to resolve their disputes, especially because these are their disputes. You are just supposed to be an arbiter. If they choose this manner or this method or this regulation, who are you to question? Especially in our legal tradition, the common law tradition, whereby the court is primarily the arbitrator, and the adversaries are, the parties who are submitting to the court. The court will not proactively intervene in what you have agreed. Yeah. So if you have agreed, then it will be very difficult for the court to untangle what you have done, because you have done it to yourself. It's not the court who actually brought it to you. Yeah. So the court will always need to take into consideration this aspect as well, i.e. to preserve and protect the constitutional guarantee on freedom of religion and freedom of choice in terms of resolving private disputes. We are not talking about public dispute, but private dispute. Yeah. And some other questions that we may still continue to ponder. If you want to put a condition, like the recommendation under the board's report, what kind of conditions can be applied or can be used to ensure that the Shariah arbitration will be done in the orderly manner? Of course, in this respect, again, like I said, to be fair, should it be compared with the practice of other religions as well? Yeah, because other religions may have their own methods and their own concerns. Madzlan by the Jewish community is just one example. From my research, I find that the Sikh community also have their own tradition of resolving such dispute. Yeah. And finally, given that arbitration has been used for decades in commercial space, so to what extent should and could it be extended to incorporate religious law? Based on at least the practice of Islamic banking, not only in Malaysia but elsewhere, even under English law, it has been proven that it can work within a modern context. It just need, maybe additional framework, supporting framework, proper governance and due process. But we do have the skills and diligence to do it. Yeah, it's just a question of basically consolidating those skills and diligence so that it would be able to accommodate what is needed or required by the society, especially recognizing that in this global world, there's no way that you can uniform everything. In fact, unifying and uniforming everything has been. You just should recognize the pluralism of feature of the society, accommodate them, as long as it does not compromise the rights of the majority, and continue and move on. So what's wrong with pluralism? What's wrong? Isn't that basically the nature of man, to have different and unique features? Even it doesn't it, basically accommodate the different needs, which is more fair, not equal but fair to the different needs of the different societies. So this is a very serious question that judges and policymakers need to consider as well, because there's no sin in accommodating pluralism. I would like to share some case study. What I have on my slides are very few, just a couple of cases. Firstly, Musawi versus RE International, and the other one is Jivraj versus Hashwani. These are both cases in the UK courts. Just to sum things up, basically in these cases, the two parties agreed to venture into a business deal. It didn't work out, but both of them have agreed in explicit manner in their JV agreement or their partnership agreement that they will refer any dispute to their mullah or their qadi or their imam. And the court in the UK recognized that these are valid process as agreed by the parties, and therefore the award is binding. Just to again highlight to you a similar case, very similar to Musawi in RE International here. In the case of Musawi, the joint venture is to develop a land in Wembley. There is a case in the UK called Abdullah versus Mursi. Abdullah versus Musi. This is a case in 2009, decided in the Court of Appeal in Minnesota, in the US, whereby the parties agreed to enter into a similar joint venture to develop a restaurant, yeah, Al Bustan restaurant. And the deal didn't work out. They get into dispute. They have agreed to table their dispute or submit their dispute to a qadi who decides on the dispute. And the question then is whether the court recognized that arbitration award as binding, legally effective and binding. And it was the case. We can also look at some more sensitive, especially for female, family disputes that has gone into arbitration. In the UK, the more a very recent case called Uddin. I'm not sure who. I can't recall what's the other party's name. But there's a case called Uddin. Uddin is actually the father-in-law who sues the bridegroom, whereby his daughter married in. These are Bangladeshi community who married to each other in the UK. His daughter married to the bridegroom, but before consummating the marriage, they decided that it would not work out because it was an arranged marriage, which is not uncommon for this community. They decided to divorce. Yeah. So the bridegroom made a claim of £25,000 of the gifts that he has given to the bride, and the bride counter-claim £15,000 of mahar that has yet to be paid to her. Okay, this is a family dispute which has to be regulated and decided according to Shariah, because there are proper Shariah principles that apply to this type of marriage arrangement. So the arbitrator made a decision, and he was later on called by the court. This actually went even up to the Court of Appeal in the UK. So the Court of Appeal called in the arbitrator to explain why the decision is such. And the arbitrator explained that under the Sharia law, when the bridegroom give a set of gifts to the bride, this is considered as hibah, simply gifts. It is without consideration. So when the contract is a contract of gift without consideration, you cannot ask for it back. In the Malay word, buruk siku, very bad manner to ask back for the gift that you have given, especially when it was without consideration. But as far as the mahar is concerned, it is an obligatory and mandatory consideration for the marriage. When you ask a woman for the marriage, you ask the hand of a woman for the marriage, you must pay his mahar, which is mandatory under the religious principle. Otherwise, you are not supposed to consummate the marriage. And in this case, the evidence shows that the non-consummation of the marriage was not caused by the bridegroom. Sorry, by the bride. So again, you have to pay the mahar, because these are mandatory, these are contractual, and therefore the bridegroom wins in the counterclaim. The court actually recognized that arbitration award. In another family dispute in the Texas court, I'm trying to recall the name. The question posed before the court is when the couple entered into the marriage. This was a case in 2003, quite some time back. When the couple entered into a marriage, they actually entered into an arbitration agreement, which says that if we happen to go into a divorce process, then we will seek an arbitration with the Islamic Council of Texas. Yeah? So they will appoint arbitrators from the Islamic Council of Texas, especially to determine the distribution of wealth of the couple, as well as the guardianship rights to their 2 children. Yeah? So there is proper agreement. Therefore, they abide by the agreement and went to the arbitration. The question then is how to enforce that arbitration award. And again, based on that case, the Texas court actually recognized the award given by the Islamic Council of Texas. So that's why, having said and having gone through some of these examples, which may not be very widely published or shared, which is why we lack knowledge of it. It simply proves that there are alternative dispute resolution beyond courts. All the benefits of arbitration that you would like to enjoy in a commercial dispute can be extended to other types of disputes as well, especially family disputes and commercial disputes involving Muslim parties. To a large extent, for me, it is also an enriching process for the courts and for the legal officers, because you learn of how other communities and other societies resolve their disputes and on what basis or on what justifications, yeah, and which is why in a very pluralistic world, pluralistic nation, I don't think we have much choice other than to be sensitive and accommodative to all these requirements, and therefore work together to find the best solutions for the needs of our communities. I hope that is useful and fruitful to you for this session. Thank you very much for listening. Assalamualaikum warahmatullahi wabarakatuh.